Hello, and welcome to this lecture by Wisdom Mitra, your friend in pursuit of wisdom. In this particular lecture, we would be covering the landmark cases that have been important milestones in progress of judicial thinking in independent India. And to begin with, let me cover the very first case, and that started and its verdict was given in 1950. The very same year in which Constitution was formed. Right. So, what was this case about? It's A.K. Gopalan versus the State of Madras, and the petition was about is preventive detention, in view of Article 21, a legal thing, whether it is allowed to have detain people in the name of law and order in a preventive manner when they have not committed any mistake. So this particular case allowed preventive detention. The second important landmark case that is important for those who are focusing and studying both UPSC as well as law set exams, CLAT exams, etc., is Shankari Prasad versus Union of India. It was regarding First Amendment, and the bench size for this particular case was five-judge bench, and it was verdict was given in 1951. And the most important point about it is that whether right to property, its curtailment under First Amendment, is it allowed or no? So if you guys know, First Amendment introduced ninth schedule in Constitution, and on account of ninth schedule, basically any law which is there in ninth schedule, which has been listed in ninth schedule, cannot be challenged in judicial courts. That was the thinking at that point of time. That was, the act at that point of time, the change in the constitution at that point of time. So this particular aspect was basically contested in this particular case, Shankari Prasad versus Union of India. Let us go to the next case. This case was Golaknath versus State of Punjab, and the case that was the question that was answered in this particular judicial case was, can fundamental rights be amended? So it was a bench size of 11 people, 11 judges, right, in the year 1967. And here the Supreme Court gave a verdict that fundamental rights are sacrosanct and they cannot be altered, they cannot be changed. CGI at that point of time was K. Subbarao. Now the point is, eventually, this particular thinking evolved, it's changed, and in place of fundamental rights not being changed, in place of this idea and thought, the idea that came into place is that basic structure of constitution cannot be changed, whereas fundamental rights can be changed. So, for example, through amendment number 44th, the right to property was eventually moved out from fundamental rights and it was put just as a legal right. So this is just one example. Moving forward, this is considered to be one of the biggest judicial discussions or cases ever, because till date 13 judge bench has never sat for a particular case except in this particular issue, where so this 13 bench judge bench is the biggest bench of Supreme Court ever. And at this, the discussion was about whether a constitution can be amended to any extent. And Keshav Nanda Bharti versus State of Kerala, this was the case about, right? And here the Supreme Court, with and these 13 judges, they came with the verdict that the basic structure cannot be altered. Even fundamental rights can be altered, but something that defines the constitution, for example, federal way of governance, or say parliamentary method of governance in India, right? So these are considered to be the basic structure. Similarly, say secularism, though federalism is not at all mentioned in constitution explicitly, but the way laws have been structured in constitution, it kind of is in line with federalism. So those aspects of constitution which define the basic structure, they cannot be altered. In fact, in one of the other lectures, I have discussed in detail about the basic structure. But the point over here to be remembered is that this is one of the biggest cases, judicial cases, which everyone who is preparing for competitive exams should know. And 13 judge bench, the biggest ever, sat for this particular case in 1973. Right. And the question that was answered is that the basic structure cannot be amended, and this thought still prevails. This idea of basic structure is still available in the judicial thinking of India. Next case is Indira Gandhi versus Raj Narayan case. Article 329A of Constitution, which was introduced through 39 Amendment, this was challenged. Basically, this particular amendment was that uh, any court cannot challenge the election of prime minister and speaker in accordance with this particular article. So eventually, the court gave a verdict that 329A4 was deemed unconstitutional, though the PM was allowed to continue in her seat. So basically, Indira Gandhi, who was prime minister at that point of time, she got into this particular case with Raj Narayan, who was her opponent in election. And the case discussed this point around 329A that says that courts cannot review or challenge the election of prime minister or speaker. So this was the case pertaining to it. Yet again, important case at the time of Prime Minister Indira Gandhi, ADM Jabalpur versus Shivakant Shukla. This was a habeas corpus petition under Article 32, and the case was all about detention under Maintenance of Internal Security Act. So during emergency, whether people can arbitrarily arrested, can MISA be implemented? Those were the questions that were asked. And this case is also called as habeas corpus case, very famous case, 1976. The lone dissenting voice in this particular case was Mr. Hans Raj Khanna, Justice Hans Raj Khanna. So you need to know this. So if you are preparing for any exam pertaining to say lawsuit, CLAT, etc., this is an important point. Next case is Maneka Gandhi versus Union of India. Verdict given in 1978. Bench size of 7 people. All about Article 21, personal liberty. Right. So basically, Miss Maneka Gandhi, sorry, was uh, like her passport was confiscated, and it was said that it's being done in public interest. So she went to the court and she fought, and eventually it was said that right to go abroad is part of personal liberty, which falls under Article 21. So, like a person cannot be unduly or unnecessarily detained from leaving the country, just like that, right? Next case is Minerva Mills versus Union of India. Yet another important case. It strengthened the idea and concept of basic structure doctrine, and it pointed out about the balance of fundamental rights and directive principles. So eventually, based on this, the idea now, or the thought process now, is that any idea that has been introduced through directive principle, it cannot be achieved by trampling upon the fundamental rights. So the means that are adopted for implementing directive principles, they should not be trampling upon fundamental rights. That's the idea here. And basically this case struck down a few clauses of 42nd amendment that ousted judicial review. Yet again important case. And these two three cases, Golaknath, Keshav Nanda Bharti, Minerva Mills, these three cases are considered to be pearls of the same string of judicial thought evolution. And I would really suggest you guys to kind of review and understand, read about this case. Yet another bunch of cases, in fact, it was he's Mr. MC Mehta. He's a lawyer by profession and an environmentalist by choice. He has filed multiple public interest litigations. Say for example, Taj Mahal case filed a writ in 1986, Ganga pollution case, oleum gas leak 1985. This was like immediately after Bhopal gas tragedy. So multiple cases the gentleman filed, and it helped evolve the environmental thinking, and the thought that there should be acts, rules that limit the environmental pollution. He became a source for many such, or I mean, these cases became source for many such, you know, initiations. Next case, Indira Sahni versus Union of India. This was again about reservations, also called as Mandal case, 1992. Pretty big bench of 9 judges, and it was a PIL. And eventually, the court held that OBCs, other backward classes, can be provided reservation on the basis of economic backwardness. And I believe in this very case, it was suggested that you should not cross 50% of available seats, etc., for reservations. Come whatsoever may, 50% shouldn't be crossed. Yet again, case SR Bomme versus Union of India, quite important, bench size of 9 people, and it is about precedent rule in states. Basically, Mr. Bommai was a former chief minister, I believe, was of Karnataka, and when some of his MLAs, moved out, defected, his government was declared like void, and presidential rule was implemented in the state. Though he attempted to prove his majority in spite of those MLAs moving away. So he said that I should have been given chance of proving my majority on the floor, that is in the legislative assembly, rather than um, s- my government being dismissed. So this um, verdict, it kind of restricts arbitrary dismissal of state governments. It kind of points out that, as Dr. B.R. Ambedkar, the drafting chairman of Constitution, he pointed out that this precedent rule should be used arbitrarily, not arbitrarily. I mean, sparingly, but it's being used arbitrarily. That was the point, and it kind of even the Sarkaria Commission that pertains to state-center relationships. Court pointed out that even these committee has suggested that presidential rule should not be just like that used. Vishakha versus State of Rajasthan. It's an important case because it led to multiple acts pertaining to safety of women, especially at workplace, led to Vishakha guidelines, and it has a very tragic background story, in the sense a lady who was a worker. She kind of attempted to stop child marriage, and while doing that, she was molested, and on that account she went to the court, so on and so forth. So there are multiple issues behind it, but eventually the thing is key. Subsequent to this case, many guidelines were initiated, and it's considered to be a landmark case in context of women's safety at workplace. IR Kelho versus State of Tamil Nadu. This is regarding limiting the ninth schedule immunity for the law. So if you remember, I pointed out in one of the cases that questions the validity of First Amendment, in which ninth schedule was brought in, and any rule, any act, which if it has been placed in ninth schedule, it at that point of time the thought process was that it cannot be questioned in the courts. But eventually Supreme Court held that all laws, whether placed under ninth schedule or no, after April 1973, which is case of Nanda Bharati date, are subject to judicial review. You cannot say something which is like in ninth schedule cannot be put under judicial review. So this is a landmark evolution of thought process of judiciary, where a law can be questioned if it's ultra virus, if it is against constitution. Share Single versus Union of India, freedom of speech related, especially online. So, on account of this particular case, the court, struck down a particular section, that is 66A of IT Act 2000, that kind of criminalized, some behavior online. I believe it was about putting something online which hurts someone, or something on those lines. So basically this case kind of helped in evolution of free speech, especially online. Yet another case Puttaswamy versus Union of India about right to privacy, also called as Aadhaar case. And it was said that right to privacy is an important element of Article 21. Yet again, big bench strength and a very important case, 2017. Joseph Shine versus Union of India regarding adultery, bench size of 6, and this particular case declared section 497 of IPC dealing with adultery to be ultra vires. So this is an important case that students should know about. So yeah, these were the cases that I felt are important and relevant, especially if you are preparing for CLAT, LAWCET, UPSC, etc. And these kind of point out to the evolution, the way Supreme Court thinking evolved over the independent India in last 70 years or so. So I hope you like this lecture, and I would really look forward to your comments in the comment box. I would like you to kind of follow, let us know what else would you like to hear about, and drop a message on the email ID provided and the phone number provided if you are interested to inquire about new batches. Thank you.